Hi, thanks for tuning into Restaurant Worker News. My name is Graham and I'm your Michigan correspondent. We're filming this special edition today for workers in Michigan. We've been seeing posts through different platforms like the Detroit Restaurant Worker Forum and Service Industry Workers of Ann Arbor on Facebook from workers saying that they're getting notifications from the unemployment office telling them that they owe money back to the state of Michigan. This has been causing workers a lot of fear and anxiety, and so we wanted to get to the bottom of the situation, figure out what's going on, and what workers need to be doing. I spoke to Tony Paris, who's the lead attorney at the Sugar Law Center for Social and Economic Justice, to see what workers need to be doing in this situation. In the first half of the presentation, Tony's going to be telling you about the Michigan Unemployment Agency, why things are acting so screwed up, and in the second half of the presentation, he's going to be going through a booklet he wrote called Making Your Best Case, and going through step-by-step information as to what you need to be doing if you've been getting a notification like this. The full legal presentation is about to follow, but here are some of the steps that you need to be taking. 1, continue to file. Even if you have a notice that says that you owe back money, keep filing your claims every 2 weeks. The second thing you need to be doing is checking your file as often as possible. Ideally, you want to be doing this every day, but if not, every other day or as often as you can. The third thing you need to be doing is go back through your correspondences, go through the tab that says View All Letters, and look for correspondences that indicate any sort of misrepresentation. If you have correspondences that say that there was a misrepresentation, you need to file a protest. If you file a protest and your protest is denied, file another protest. When you file your protest, you'll have an initial hearing with someone from the unemployment office. From there, they might try to schedule an appointment with an administrative law judge or ALJ. Once your hearing with the ALJ is set up, contact the Sugar Law Center or one of the other advocacy groups that Tony talks about. Hopefully you enjoy this presentation and find it useful. If you want to continue to support the work of Restaurant Worker News, please follow us on Facebook at Restaurant Worker News, Instagram at Restaurant Worker News, and on Twitter at Restaurant Worker News.
Hi, everybody. My name is Tony Paris. I'm the lead attorney at the Sugar Law Center for Economic and Social Justice in Detroit, Michigan. I'm here with Graham, and I'm going to go through some unemployment insurance rights and other types of strategies that might help you all, especially folks who are worried that they've received correspondence that they either are ineligible for unemployment insurance benefits or otherwise have some type of debt that the agency is flagging them for. I've done this type of unemployment insurance work for over a decade now, strictly on behalf of working people, mainly on behalf of restaurant workers and service industry workers, low-wage workers, and other folks who are displaced by, no fault of their own. Michigan's unemployment insurance system is supposed to be there for you during not only times like this, a global pandemic, but any time that you lose your job due to no fault of your own. And unfortunately, the system is full of glitches and other issues that continue to arise, which can deter folks from filing for benefits, deter folks from continuing to certify for benefits, and otherwise kind of scare folks into not taking advantage of benefits that they are actually entitled to. And throughout this process, Graham, myself, and many other resources are here for you in order to make sure that you get everything that you are owed and that you don't have to worry about paying back debts or otherwise not being on unemployment while we work our way through this unprecedented time. To begin with, I know many of you presumably have either opened a MyWham account or otherwise received correspondence through the agency electronically through this Michigan Web Access Module account. MyWham, on one sense, can make things much easier because you can file the protest that I'm talking about just with a click of the button and a few boxes being checked. However, in many other ways, MyWham is problematic. Number one, Sugar Law Center has been in federal litigation now for roughly 6 years because of MyWham's issues with providing adequate notice to individuals. Notice that is supposed to be given through an email address as anything is posted on your MyWham account. Unfortunately, what we see with MyWham communication is that sometimes you get notice that there's a posting when there is none. Sometimes something's posted and you don't get an email. Sometimes your email has allowed that communication from MyWAM to go into your bulk or spam or junk folder. And so many folks, it's common to miss communication through their MyWAM account. While you have a potential issue pending, or while you have a potential debt pending, or while you are not collecting benefits and wondering what is going on, it is very important to check your MyWAM account daily if possible. Many of the deadlines that we have can sneak up on you quick. To answer a fact-finding question or provide certain answers to questions, it's usually a strict 10 business day deadline. To protest a determination or redetermination against you, it's a 30-day deadline. And of course, because of this being a digital system, many other problems exist. The fact that the system itself is programmed to flag certain things automatically or be very strict in its deadline enforcement, or because back in 2013, the Michigan legislature decided to spend a lot of money to put in the MyWAM system in a part of a larger system called the MIDAS system that you can just Google and see all the problems with. Because of that issue with the digital programming of the whole thing, coupled with the fact that there are lack of staff able to address these issues, and third, with an unprecedented amount of folks on unemployment who need it, have really made for quite a cocktail of problems. The system was already broken long before a global pandemic. So you can only imagine what folks are going through now as they are unable to get through to the agency. They are unable to get through phone, through chat, through scheduling anything. And so really, many folks just feel like they don't know what to do. There's good forums out there, like the Detroit Restaurant Worker Forum, who are going to continually provide certain rights for everybody. But at the end of the day, if you can't get through to somebody, it is best to just continue to check your MyWAM and to potentially contact myself or Graham with the numbers that I'm going to provide at the end of this presentation. So many folks very recently have noticed either debt on their MyWAM account, that they've been overpaid, and at the top of it is asking you to remake a payment on some number from anywhere from a few $100s to tens of thousands of dollars. Many folks are noticing a misrepresentation issue on their account. Some of them are seeing that the misrepresentation issue is pending an evaluation. You should know it's very important that the misrepresentation issue, which you probably see in your Correspondence tab or sometimes in your Determination Status tab, if that issue ever says misrepresentation found or ineligible, and it's not just pending or no misrepresentation found, which are fairly good things, they should contact me immediately. The misrepresentation issue is something that it's important that we nip in the bud early, because generally the misrepresentation issue can cause a few problems. It can make the agency find you ineligible to try to get any more future benefits, first and foremost. It can add a penalty on benefits that you've received. It can prevent you from using other potential avenues to not have to pay back any debt. And it makes anything later on down the road, a bankruptcy or anything else that we might need to be ineligible. The good news is under Governor Whitmer and the leadership that has taken over, coupled with the success that my law center has had in some federal litigation, the misrepresentation issue now is required to receive human review. The computer is no longer allowed to determine that. And the good parts about that is once a human being evaluates the different fact finding and the issues involved, very often, if not all the time, since the pandemic and leading up until Governor Whitmer taking over and appointing a new director, we have not seen the misrepresentation issues and decisions against claimants that we used to see. That's a knock on wood situation. That might change at any moment, But for now, at least in 2020, I had not seen a misrepresentation issue that was auto adjudicated by this broken system. It was normally, although it took some time, even if it had to be flagged, a human being was able to go in and remove that. That's good news for now. Let's hope that that continues to be the case, and let's hope that the leadership in the state of Michigan continues to acknowledge the importance of not trying to enforce a misrepresentation issue on some of the flimsy evidence that they used to, just because they actually think it might deter folks from receiving unemployment. Although that's a good thing that the misrepresentation issues don't seem to stick, they use language that's meant to scare you or deter you or to have you give up on unemployment insurance benefits. It's very important that you don't use that strong language to, I guess, throw up your hands and say, well, I'm just going to get off of it. This is too frustrating. If you do that, they win. And as long as you're honest and as long as you do your best to answer the questions truthfully and report any earnings you might be making, if they're part-time or due to underemployment, they're going to have a very hard time, if not impossible time, proving misrepresentation. But they win if you stop filing and you stop certifying. They're going to be allowed to say that unemployment insurance filings are down, not because they've created jobs or good jobs or because the pandemic is over. They've done it because they've broken the system and now they want to blame the system. And that's so frustrating for folks who, like me, recognize that unemployment insurance benefits are meant for this exact thing, for this exact type of thing. And hopefully this past year has only highlighted the need to have a good, robust, liberally construed unemployment insurance system that aids these injured workers. Because at the end of the day, this should be our path on the way to a guaranteed income for folks unemployed due to no fault of their own. And I also commend the state and federal legislatures for expanding these benefits unprecedentedly to folks who are contractors, underemployed, gig workers, temp workers, folks that traditionally in American history have been completely removed from being able to collect unemployment benefits. And this is what we call PUA. What I'm talking about today applies whether you're on PUA or regular state unemployment benefits. It's the same system. It's the same avenues to protest. It's the same issues at work. And we want folks in the legislature to continue paying unemployment insurance benefits to these folks who did not have either sufficient earnings in the past 6 quarters or who otherwise recognize that many of our folks work in this gig economy, work in the self-employed economy, and they should not be punished just because their work was 1099 and juggled amongst 3 separate jobs, as opposed to the ever-decreasing ability to be a W-2'd employee paid properly, continuously in a career type of thing. So that being aside, let's talk about what you might be seeing in your MyWAM account. If you've seen that debt, and if you've seen the misrepresentation issue, it's very important to dig a little deeper. You want to first dig into what seems to be the issue there. There's not allowed to be a debt at the top of your MyWAM, whatever the number is, unless the agency has first deemed you to be ineligible under some provisions of the law, right? And it's not just the misrepresentation issue to look for here, which is all important, but like I said, often is just pending adjudication or misrepresentation not found. Also, those 2 things you don't have to worry about yet. Of course, if you do, although in the rare case, see that misrepresentation's been found, you want to look at protesting that and call me or Graham. But more importantly, misrepresentation is not allowed to exist unless it's attached to another disqualification, some type of parent issue, we call it. The misrepresentation is the child. You can't find fraud unless you first find you were ineligible under a quit provision or a refusal of work provision or a failure to produce identification or a misconduct provision. A ton of different types of reasons that you could be found ineligible with this computer system. But it's not allowed to exist on misrepresentation, can't exist in and of itself. So we have to double, triple check to see what could be on your MyWAM that actually is also finding you to be ineligible. I've talked to people just this week who have no misrepresentation found, but have debts on their account, or misrepresentation pending and have debts. Well, that means that it's not just the misrepresentation issue that's going on. There's something else going on. And I can't stress how hard the MyWAM system is, how non-intuitive it is, non-user-friendly it is. And of course, I believe it's that way for a reason. They don't want it to seem too easy. They don't want you to be able to get simple and effective ways of exercising your ability to be eligible for unemployment benefits. They want it to be difficult, to be confusing. They want to deter you. They want to make you earn it, right? So you're going to be checking your MyWAM every day or so while eligibility might be at issue. That's the most important thing. And number two is continue to certify. Whatever day of the week, every couple of weeks you've been given based on either your last name or your social number, you have to call in, because if and when we prove you're eligible, if and when we win, if and when your protest is successful, even if we have to go to a phone hearing and you use me as your attorney, you're only going to get all your back pay for the time that's been hung up if you've been certifying during that time. So continue to check your MyWAM, continue to certify. If, like it has for some folks, although not many, prevents you from certifying whatsoever during this time period, now we have to do an all hands on deck to get through to the agency, because the lack of certification is something that even the agency has prioritized as far as, okay, you need to get in to at least preserve your eligibility. This is one of the criteria that they allege that they will call you back for. This is one of the criteria that they will allow my liaison, a liaison given to all legal service workers, to quickly address. And that issue is very important. Of course, I guess I maybe should have started, even more important is if you don't have a MyWAM account or can't access a MyWAM account. Although snail mail is a good thing to double check all your communications, and if you have MyWAM, you should not be only go green, but also elect to get courtesy hard copies of those issues or fact findings or decisions mailed to you. At the same time, MyWAM, although problematic, allows you to do quicker protests than mailing something in, than faxing something in. Based on sometimes my folks get a mailing a week or two later than when it could have been issued on MyWAM, right? But that aside, if you can't get into your MyWAM, that's something else the agency is supposed to prioritize, and something else that we should be an all hands on deck type of situation for. So once we're on our MyWAM account and we see these issues, here's what I always tell folks. Beyond certifying and beyond checking it, check where, right? MyWAM, in its lack of user friendliness, actually has tabs that you should be clicking upon in order to see what might have been slipped into your account that's finding you ineligible, right? These main tabs are the Correspondence tabs and the Determination Status tabs, right? Correspondence tab is the most important, and here's why I find it to be confusing. Many of my folks have maybe looked at a document, or maybe because their email directed them to it, it opened. So a lot of them say, there are no unread letters, right? No unread letters. View them. They think, oh, nothing new has come. I don't trust that. You want to go to your View All Letters tab, right? And it doesn't even look like you can click on that. It's like a box that's off to the side of each thing. But when you click on that, it gives you everything they purportedly have sent you. Monetary determinations, which are what you get when you first file or open your claim. Non-monetary determinations, extremely important for me, because that's some type of decision about your eligibility that deals with something the employer might be flagging, or that the state of Michigan might be flagging. This is your quits, your fireds, your refusing works. The non-monetary determinations are huge. And of course, your fact finding. Sometimes this is called requests for information related to possible ineligibility. But the fact findings are important because they're supposed to go out before a decision's even made, before you're even found to owe any debt. This fact finding is supposed to go out with different questions depending on the issue. And they're canned questions and oftentimes digitally set up for box checking or whatever. But based on those questions, you can kind of know what might be at issue or what the employer might be looking at or the state of Michigan might be looking at. All of those should be in your correspondence. Again, 10 days to respond to a fact finding, 30 days to respond to the determination. But I also want you to read those documents carefully. Many of my folks, they don't read the determination carefully, and the agency uses really, really bad language with the determinations. Things like, you are not ineligible for benefits, right? These wonderful double negatives that when my folks are scared or confused, they just start clicking protest to anything because they just see a debt. We really want to make sure it's not in your favor before you protest it. Because although eventually the judge might say, well, I don't have jurisdiction because it was in their favor to begin with, that protest still might hang up you receiving benefits while it goes through the now backlog of time to get to those next levels, right? And so you want to read them carefully. Obviously, I'm here for you to help you interpret anything you don't understand. But really, the agency is going to issue those decisions finding you to be potentially ineligible before misrepresentation is even attached and what's causing your potential debt. I've been told another problem with the MIDAS and MyWAM system is that the misrepresentation issue has to be evaluated, even in cases where it's clearly not, that it has to be evaluated anytime the underlying parent issue has to be evaluated. That the computer's algorithm or the if-then, programming, if you will, has to go to misrepresentation anytime you could also be ineligible for something else. That way it's like, okay, they might be ineligible because they quit, but also, if so, did they do it on purpose? And although they call it unintentional misrepresentation, which is very bizarre, that's fine. It means that you're cleared on all of that. And a human has presumably looked at it and said, oh, this is a difference in info from employer to worker that could go either way. Or I received information from the employee that they're clearly, doing their best or being honest. But they claim it has to go through there. Obviously, I think it's because they're just trying to scare you away from collecting benefits. But this is the algorithm that we're working with at this time. So don't be deterred just because you see that word, or because every time you submit a protest or a fact finding, it now has a line in front of it that says, hey, your penalty of perjury if you decide to submit anything incorrectly or whatever. Just remember that that's meant to be there for a reason, and that we will work very hard to show that as long as you were doing your best to understand the system, that there was nothing deliberately done. You should also know that the successes the Sugar Law Center has had in federal litigation in the past 6 years make it now where there used to be 4 times penalties for misrepresentation. If you got $10,000 in unemployment benefits, they'd require $50,000 back. We got rid of that through our lawsuits and some bipartisan legislation passed in 2018. There's no longer those high penalties. I think it's only 1 to 1.5 times now. Before our lawsuits, they could go back 6 years to search for any type of misrepresentation, and a ridiculously long statute of limitations. That's all changed. Now it's 3 years. We also prevented them from denying folks advocacy assistance because of a misrepresentation flag, which now not only can you use Sugar Law Center, but you could also potentially use the state's advocacy program to address some of these issues. And a lot of these things are good, but not far enough, if you ask me. A lot of these things need to be changed because the last thing folks need is in 2 or 3 years to have a change in our state government that all of a sudden they get flagged for something that they're not even on unemployment anymore for, which is what happened in our state, unfortunately, from 2013 to about 2017. So once you have your MyWAM open, and usually if you need to talk to me, I have to schedule a time for you to even have that open. I have you go through those tabs anyway. And the correspondence and determination status tabs are important. But here's the last thing that I think is key. Those tabs have different communications, different letters, if you will, for every claim you've potentially filed, right? And many folks not only have had to open multiple claims because they learned they weren't eligible for regular benefits and had to go to PUA, or they had to open a separate claim because their benefits exhausted and they had to open another claim, or they were confused and shut off of one claim so they kept trying, whatever the reason might be. They had to do that. And if you look up on the right-hand side of your MyWham screen when you're on the home screen, again, buried in these little hyperlinks, it says View All Claims, right? And when you click View All Claims, it'll have a long claim number. Pretty much any time you've ever been on unemployment, before the pandemic even, it's supposed to keep all your claims from at least 2013 on. They look grayed out. They look like you can't click them. They almost look like they're dead links or something like that. Turns out you can. And inside of each of those claims, even if it was a pandemic claim you did from March to August of last year before you went back to work for 2 months, there might be letters hidden in there in the Correspondence tab. That's how hard some of these documents are to find. Yet, if we don't get to one of these documents within the timeline, the 30 days for determination and the 10 days, we have this whole new hoop we're going to have to jump through to prove you're eligible. This good cause issue, that you have something outside your control or something that prevented you from protesting this in time. And the state and employers are getting better and better. And of course, there's some judges that are tougher than others at saying, well, you still were in control of your MyWham, you still were checking it, or whatever they think to prove or try to prove that you didn't have good cause. And if we don't show that you have good reasons for being late, we're not even allowed to talk about the fact that you're eligible or that you didn't commit any misrepresentation. We're not even allowed by law. There's no jurisdiction. Good cause has to happen as a precursor before you're even allowed to go into any of all that. It's very frustrating. And usually when my folks come in, even folks with degrees, with, smart folks, they sit in my office or I'm on the phone with them and they notice something that they did not notice before. And that's my first round of advice before you need any type of advocate or attorney assistance, is to continue to check that. If the document is self-explanatory, finding you ineligible, you don't need me to write a protest. You don't need Graham or anybody to write a protest. If it says that you refuse an offer of work and you've had trouble getting a hold of me, you can just click the protest button right there. Again, I still think it's best to click the MyWham protest buttons because the fax, which is second best, right, is I find to be more delayed than ever during the pandemic. I think it goes into a different, state account or something than a MyWham protest. And snail mail, I highly don't recommend protesting that way unless you absolutely have to. So you'll click protest. You can always try me. But again, 10 days, 30 days. You don't need a lawyer to protest something at that determination level. Sometimes if you're even confused about what to write, this isn't true. I did not quit. I disagree with this. And just sign it. Okay? I didn't quit my job. I was fired on this date. Here's the text message. Or I did quit, not permanently, only because of COVID concerns, because I'm immunocompromised, or because I stay with somebody or take care of a family member who is, or I have additional childcare issues because they're home right now, because of Zoom school or whatever it might be. Very, very important that even if you can't get to me, that you know that the determination protest is something that at best, you're lucky if a human even looks at it, right? It's usually just staged to the next level. Sometimes humans do look at the protests. And remember, they do. Who knows? If they're just trying to pump through them and they say it, not enough, not enough, not enough. Sometimes, although less than half the time, a human being looks at your protest and does overturn it. But the majority of the time, they just rubber stamp the denial and give you a redetermination. By far the majority of the time. Then you're going to get a second denial potentially. What are you going to do? Not going to throw up your hands and say, I guess this is it. I protested the same thing twice. It's pointless at this point. That's how many of my folks make a fatal mistake. One more protest, even if it's the same cut and paste as your last protest, and it stages you to get a phone hearing or phone interview with an administrative law judge. This is by far the most important stage of your unemployment insurance eligibility and showing that you're entitled to benefits. It's oftentimes the first time you get to talk to a human being, let alone one who knows unemployment law, let alone one who's independent of the agency's biases, let alone one who has the power to issue an order forcing the agency to find you eligible. And that's when I highly recommend you don't go alone. At the hearing level, you use either myself, the advocacy program. There's a clinic out of U of M Law School, the Workers' Rights Clinic, that advises people regarding that. And that you only remember, if I get scheduled for a phone hearing, I don't care who it is, I need to talk to somebody to potentially advise me on that. Don't need it at the stages before, the determination protest and the redetermination protest. But at that hearing, please don't go alone, and make sure that we talk through whatever we can to help you all. Years ago, I wrote a little booklet regarding folks who I felt leading up to their hearing, if we were overwhelmed, might need to either represent themselves or otherwise information that they should know while they write their protests. And it's called Making Your Best Case. It's a little booklet. Some of the info in there is slightly dated as far as the names of various agencies and appeals commissions, but most of it is still the law of the land. This is something that can help you. It's not written in a neutral way like the agency's materials. It's written specifically to tailor your arguments in either a protest or in your hearing to give your best side of your story, to give your best case on all of the main types of things that could be disqualifying you. Quit, fired, and refusing work are huge, but also there's a section on there on misrepresentation. There's a section in there that just kind of describes basic things you should know before you're in a hearing. I'm going to pull that up now to go through kind of some of the big issues in light of COVID that I think you should be focusing on, which I bet the majority of you are being flagged for or otherwise being denied for. These are quit issues, refusal of suitable work issues, and availability issues. Importantly, before I pull it up, you should know, especially with suitability issues and availability issues, that the governor's executive orders of last year, coupled with some federal up-and-coming determinations or issuances by the Department of Labor, are going to expand those things. Governor Whitmer passed executive orders specifically to say, okay, now we're changing suitability factors because of COVID. Now we're changing when you can refuse to come back because the job isn't suitable yet. Now we're going to change availability provisions of the act, right? The unfortunate part is some of those are in legal limbo, because in October, the Michigan Supreme Court found in a 5-4 decision that Governor Whitmer was without authority to do some of those. And of course, luckily, the state then scrambled and passed bipartisan legislation to kind of codify what was in her executive orders, but they didn't codify everything that was in them. And so sometimes in hearings, we have to kind of use arguments that involve some of those executive orders that we believe were the law of the land or otherwise should be the law of the land and considered by administrative law judges. Number one, that your availability, if you are home because of a COVID concern, childcare issues. Previously, if you had a childcare issue, that wasn't the employer's fault. And although it's one of the best reasons on earth to not be available for full-time work on any shift, it would disqualify you for unemployment benefits. Transportation issues, another good reason, right? Something's wrong with your car or whatever. Well, again, if you're not available for full-time work on any shift, that used to disqualify you. Governor Whitmer's executive orders have changed a lot of that. They've addressed those issues. Many folks who rely on public transportation, which is up in the air at best with COVID, now if they have that issue, they can actually still be found to be eligible. They have child care issues for, let's say, a babysitter or a school that now they have to stay home with their children during remote situations, then that won't disqualify you. And so a lot of those things are important to bring up, beyond the fact that if you're immunocompromised or caring for a family member or need to quarantine for any reason. Those are all also good reasons. And many folks just maybe forget that one of the bad parts of Michigan unemployment insurance law is that these exceptions aside, you have to be available for full-time work on any shift. So when you're answering questions, which I know many of you got when you refiled for benefits and you were finally able to certify for that gap in time after the end of the year when they ran out, and now you're eligible for continued benefits through at least March with some additional potential money on it. The problem is many of those folks got questionnaires kind of weirdly worded to get you to mess up. Are you available for any work, right? So many of my folks confuse the situation and answer that they're not because their employer is either closed or because we're in a global pandemic. Now, of course, that's true, but the computer system is so rigid in its algorithm, it only sees any of limits to availability and flags you into the other pile. And although we might eventually easily win that, that could take weeks to months of not receiving benefits in the meantime, just from that simple thing where my folks were confused and they didn't know that any limits in your availability could find you ineligible. Any limits in, you having connection to the workforce previously for my PUA folks could potentially flag you as ineligible. And so that's why I want you to defer on answering those questions to show that you are available. If this was not going on, if this pandemic was not going on, you would be available. And to know that, of course, if this was not going on, there could be separate arrangements for you to work on various shifts or whatever it is, right? So that's all very important. Now, to help you in case you need to protest any of these documents you see in your MyWAM, causing this potential overpayment, causing a potential misrepresentation issue to attach, you'll know how to potentially write your own protest without me. And I'm going to try to screen share my document now. And Graham, does that look like that's working?
Yep, you're good.
Great. So again, I wrote this, I think, almost a decade ago, but the most important parts for you to check out are really, the 1 through 5 sections, right? Again, employer independent contractor, luckily with PUA, even as a contractor, you're potentially eligible for PUA benefits. Preparation for the hearing, maybe if it's an emergency, but I want to be there with you for that. At the hearing, same thing. And fraud, hopefully, the state's human review of all these claims continues to not find misrepresentation or fraud. So we're going to start mostly with 1 through 5. I'm going to gloss over some of this, the purpose and everything. I do like that little box. If you're unsure, you file. Not only for extensions, right, but for benefits to begin with. A lot of times, they make the system so difficult, they use difficult language, or they just make you plain wait too long, that you think, I just should get a job and risk health and safety issues. Again, defer on filing if you are off of work for any of the reasons that we're going to discuss. Of course, one of these steps, beyond opening your MyWAM account and opening an unemployment insurance claim, which you can do on the phone or online, you used to be able to open it in person. Unemployment agencies have not reopened as far as I know. So online is still the best way. You used to have to register in person at a Michigan Works. Put your resume on some database. You have to do that at least once. Well, that's all suspended right now. Not only because of COVID-19, but because our state unemployment insurance rate is over a certain percentage, where by statute, some of the things that you normally used to have to do, you don't have to do anymore. This work search requirement, right, is supposed to be suspended, where you don't have to fill out all of those requirements the same way while our unemployment insurance rate is over a certain percentage, or during COVID-19, thanks to Governor Whitmer's executive orders. Some of my folks have said that that's no longer the case, that they're still being required to enter in work search information. That's fine. Do it if you need to. But remember, a lot of this has changed because of COVID-19. Of course, you can do it on the phone. We call it Marvin. Marvin is the name of it. It was much more common back when I wrote this to do things over the phone than online. You can still do it by phone if you need to. I strongly recommend doing it online. Now, a lot of the stages that we're at is the determination stage. Remember, I don't think any of you will have that underlying debt that you see on your account without a decision. And unfortunately, they don't wait till the determination's protest period is done to say you owe the money back, which is what a normal responsible agency would do. The second a determination is issued, you might see that debt. The determination is going to inform you of certain things. You'll find it under correspondence. Some of you hopefully get hard copies of it as well in your regular mail. But regardless, everybody's MyWham account is supposed to include these decisions. You're supposed to get an email saying, check your MyWham, you have a new determination. I don't trust that. Continue to check it all the time. If you can't understand it, you can always try me, okay, to get a hold of me. But remember, these things are often fairly self-explanatory. You don't need any lawyer or anybody to just write in that you disagree with this. And sometimes, right, when you protest it, as I said earlier, you'll get a redetermination fairly quickly, which is C, right? However, the state, in recognizing there's a huge backlog of cases, millions and millions of folks filed, when even at the height of our Great Recession in 2008 on, that was unprecedented back then, and there was only 300 and something thousand filers. So they've recognized this, and now the agency at times is skipping the redetermination stage. And a protest of a determination gets you your hearing. The good news about your hearing, that notice comes snail mail. It will not be on your MyWham. That's very good, because obviously I don't worry about notice problems, but that means you have to keep your address updated with the agency if and when you move, or on your MyWham if and when you move. And when you get that notice of hearing, that's when you beat down my door to make sure we can get you into a schedule or get an advocate for your hearing before that. The determination you likely won't need me for, but the hearing, I want to at least make sure we get you somebody to help be on that call with you. So again, they might skip a redetermination stage, still rarer. Most of the times you'll get those redeterminations that might just rubber stamp it. And then, of course, you appeal your redetermination stage, or if you appeal your redetermination, it goes to get scheduled for a hearing anyway. That's why when you're appealing your redetermination, you don't need to worry about, am I appealing it right? Am I writing the right thing? There's no stage in between a redetermination and the hearing. There's no human to look at it. It's just staged to get a hearing. So you can say, I disagree with this redetermination. I request a hearing, period, done. That's all you need to do. Don't let any lawyer charge you for filing protests of a determination or redetermination. Don't let any advocate charge you for that. These are simple things that are often just rubber stamped anyway. And there's some predators out there that believe that they should be making money off of the back of unemployed people. The hearing, which we're going to get to soon, after the hearing, even if we're not successful, even if for some reason we lose, not only do we have other avenues we can do to prevent you from maybe paying back any benefits, there's another free appeal that occurs after that. And the only change in my booklet in the 10 years that I think is important is it's this E, the Board of Review. It's no longer called that. It's called the Unemployment Insurance Appeals Commission. Same thing, same rules, just different name. And that's what you get a free appeal for, even if you're not successful at your hearing. And that's where 3 judges or commissioners in Lansing review your underlying transcript of your phone hearing with the judge, your interview, and they look for errors, right? Again, it's all very important that you make sure before you think you have to pay anything back, you exhaust all your appeals. We can gloss over a lot of this standard review stuff. This is mostly, I guess, how high the bar is in order to win at these different levels. But in H, as I'm at now, you can see, we talked a little bit about this, but after the 30th day, we could be in trouble if you don't get a protest in. It has to be received by the 30th day. Not that you put it in the mail by then, not that you faxed it the next day, but it has to be received. And a lot of this good cause issue is very subjective depending on what judge you get. I've had judges say that a lack of understanding of the notice is good cause. Literacy issues, good cause. Just not knowing if you received it, good cause. But that's rare. Usually it has to be something outside your control. You moved and didn't get the notice. You were not at home during that time. You were out of the house looking for work, out of the state looking for work or the possibility of work. All those types of things. Because it's so subjective, judge by judge, it's best just to make sure that we don't have to deal with that issue. These first 3 of section 2 are really important for COVID folks. And again, these are based on cases that I read and case summaries that I read, but they can help you at least in your protest of a determination if you want to use some language that might help you. Voluntary leaving is very common, if not the most common under COVID. I have folks that told their employer, I'm not able to return at this time because of these various COVID concerns. The employer just automatically flags it as a quit. You must have left. You must have quit. I'm taking as what you said is that you didn't want to work here anymore no matter what. And that's kind of evil and it's kind of wrong because here's what happens. The first thing a judge has to determine or the agency has to determine is, was it even truly voluntary to begin with? And most of my COVID folks fall into this section A. It was not voluntary. I didn't affirmatively say, I quit forever, I am not coming back. I expressed my inability at this point to return to work. They took that as a quit. They affirmatively took me out of the schedule. They affirmatively said that I'm shut out of any type of apps or other types of communications. They asked me for my badge back. They asked me for any uniform or whatever. Well, that's not you quitting. If you didn't express intent at quitting indefinitely, and that's why I strongly suggest that you don't act like you're just done forever. You let them know that we're in a global pandemic, that in a restaurant industry especially, everybody knows that although the CDC and various employers have put forth on paper various things that they want to see or hope to see, once a busy restaurant gets going, all of that goes out the window. And whether they can enforce it on employees is one thing. How about whether they can do it with customers? When, quote, the customer is always right. And all of a sudden you see customers without masks, not doing social distancing, you name it, right? All of these types of things, as long as you say, listen, based on these concerns of mine, especially when they're COVID related, it's not even a voluntary separation. The employer took me off the schedule. Or even if the judge doesn't believe the employer took you off, I had no choice. I take care of my grandmother who's 90 years old. Or I have children at home all day because their school is closed. Or I'm immunocompromised. I have asthma. I have diabetes. I have various cardiovascular injuries. Because of all that, I have no choice not to return. I'm in a rock and a hard place times 10. All of those things, if we win at the initial stage of the hearing that it wasn't even a voluntary quit, automatically you're eligible. It doesn't go into this whole, did you quit with good cause? Let's say the judge doesn't believe that it was involuntary. Well, then we get to say, fine, Your Honor, even if I did quit, I quit because I have good cause attributable to the employer. It's very important in these scenarios. There's many good causes out there. America doesn't recognize half these great causes, right? Family issues, deaths, transportation issues. Unfortunately, Michigan calls all of those personal reasons. And although I strongly disagree with that, those are some of the best reasons to not be able to work at a job. We have to give our best argument. And our best argument says that the reasons that I quit weren't personal. They were the employer's problems. I had good cause attributable to the employer. And because of this issue being a little difficult, you actually have to show that you gave the employer an opportunity to address these issues before you quit. So that makes it a little trickier than just proving it was involuntary, right? But at the end of the day, what is good cause? All roads in COVID, all rivers lead to health, safety, morals, right? And I say all rivers because we'll see with suitable work issues right afterwards, all right after this section, again, a job can be not suitable because of health, safety, morals issues. So you still want to focus on building your story and your case and taking the facts that best address health, safety, morals issues in writing your protests. It's the same things that I'll do if we prep for a hearing. Give me all the things that you were hesitant, to return to and why. There's some good examples here. Some of them don't really address health, safety, and morals issues, but here's the good cause issue. Let me see here. Maybe the one that's dealing with when an employee asks to do something illegal or unethical, that might be there. Many folks are being told to look the other way on health, safety issues. Let me see if there's one even closer to health and safety issues. Here you go, top one here. Work conditions that have a significant adverse effect on the worker's health have sometimes been considered to be good cause, right? Those are good ones, both those examples. And yeah, that'll be good for now. Again, good personal reasons are not enough. As you see in my second to last example, it's generally true, and I'm sure you've all heard it before, quitting makes it harder to get unemployment. It is generally true. Doesn't make it impossible, but generally true. Here's the other common one for COVID, leaving to accept other employment, right? Well, that's tied to voluntary leaving. Sometimes Governor Whitmer tried to address this, and I think this was in her bill. In the olden days, before COVID, Michigan was one of the, I think, minority of states, unfortunately, that going back a year and a half from the day you filed, any one of your jobs that you worked, which many restaurant workers work more than one job, right? Any ineligibility, even on a job you're only at for a little while, for a weekend, back a year and a half ago, any ineligibility on any of your jobs could find you completely disqualified for benefits. It's really bad law that many folks are working hard to change in Lansing. Governor Whitmer said, number one, we're not going to have enough time or resources to go through every employer in a year and a half to see whether or not you were actually disqualified in that. All those different determinations, all those different fact findings, right? She said the only one that should matter is your most recent separation leading up to COVID, right? And luckily, many folks benefited from that because now it's just the most recent one, right before you filed back in March or maybe, whenever it was. That's huge because let's say you were in the process of going to another job or you had left a job but not worked for long enough at the new job. It still should potentially find you to be eligible, right? It's very important. And why I hope that the agency in Lansing sticks to this because it makes their job easier too. Misconduct is mostly for termination reasons. I do see some of those nowadays in COVID. Primarily what they deal with is you missed so many days because of COVID, we had to fire you, right? Or they come up with a pretext or an excuse to get rid of you because you were hesitant to come back. Or they're dumb enough to admit, yeah, we took him off the schedule. He was a bad worker. We straight up took him off. Well, then you should use this thing in writing your protests. Pretty much, you have to deliberately have disregarded your employer's interests or policies. You knew you were doing something wrong and you still did it, right? It's a kind of a high standard. It's almost like a just cause standard for union, folks that are in there. And it's very important that you just show that not only you didn't deliberately do anything wrong, but that even if there is a performance issue, if you're trying your best, you made a good faith error, you messed up in an isolated incident, but you didn't do it on purpose, you should still be able to get benefits. And those bullet points right there under the ask yourself question, or ask yourself, there at page 11, are things I still use to this day in order to properly evaluate the best facts of my clients. All of those bullet points are very, very, very important if you've been fired and want to show your unemployment insurance eligibility. Here's a little box on health issues specifically. Obviously, this should be a little bit expanded with COVID, but one of the things I notice many of my judges are looking for in these unemployment phone hearings is just some type of medical documentation that either you are immunocompromised or you were exposed to COVID or a family member that you have direct care obligations to have these issues. Somebody even potentially that you share a house with has those issues. So anything you can get from a doctor about your immunocompromised issues strongly help. Some judges ask about that right away. Okay, last but not least, suitable work and availability. These are the most important ones. When Graham and I first talked last year when this pandemic was raging and so many folks were on unemployment, I was trying to figure out language for folks who are in the restaurant industry especially, super hesitant to go back. Yet, knowing that their employer would be cutting corners, knowing that they would potentially be off unemployment, which at that time was properly paying some additional federal monies. And we tried to talk to folks and kind of draft language that talks about it being at this time I'm unable to accept your offer to return. Not that I'm quitting permanently, not that I'm done, I guess I'm not coming back, bye. Not that I resign. Don't ever let your employer trick you into using that word, right? That I'm unable, until things change, until either you show me more, employer, that things are being followed properly, until there's a vaccine, until I'm no longer immunocompromised, until I no longer have these childcare issues or transportation issues or anything, I am not able to accept your offer at this time, right? And this is where I drew a lot of that from, right? Right there, first bullet point, health, safety, morals, just like I said. Sometimes employers try to say, well, you can do other things at the job, right? If you're that worried about it. You can work in the basement. You can work doing this. You can work at a different location. Who knows? Evaluate that offer using those bullet points and contact us if you need to. All of those things, not one factor alone is the determining factor, but all of them are evaluated at the same time. And the employer will have to show that they communicated an actual offer that was specific and that the claimant refused the offer and that the work was suitable. We'll stop there now. Obviously, independent contractor is an important issue for workers. It's a little less important as PUA expands to independent contractors. And of course, for folks who do actually see the misrepresentation issue, stick, not just that it's pending, not just that they're looking at it or it's being evaluated. There is a section here, I think at the very end, that deals with that issue, right? Again, knock on wood, fingers crossed, the state continues to use human review to find that these issues are not being used. But again, anything can change, anything can happen on that. The last thing I will say is, let's say you lose a determination or redetermination, or somehow I even lose my hearing, right, with you. And your appeal to the commission after that, the other free appeal, multiple chances we got. Even if that's the case, or sometimes while one is pending, I have another trick that we can use. You'll see it right here, section B, waiver of restitution or hardship application. What this says is that even if you were ineligible and you shouldn't have been on benefits for that amount of time, if two things are the case, you might not have to pay it back, even if you straight up owe the money. One is if you're below a certain income level, which I know many folks are right now, because you're either on unemployment at best or not working. I believe it's around 1.5 times the poverty line. It's based on federal guidelines, and I've seen judges actually use the table to see what income levels they're at. You're under a certain income, even if you owe the money, it goes away. Number two, sometimes I've been successful in proving that the agency made some error, an administrative or clerical error, or some other type of glitch or problem or mistake. And it allows me potentially in a separate hearing to put the agency on trial a little bit into either why they took so long or why they didn't process documents or who knows what it might be. And those are all potentially helpful in not having you pay it back regardless. I'm really excited that many of those issues are able to go to hearing separately, right? So even if you lose a hearing that the offer you refused was suitable, we could get a whole nother phone hearing on whether or not you make enough to pay it back. And you just have to fill out this 2-page application, which I'm going to share with Graham at the end of this, so he can circulate it to folks if that applies. Lately, because of the huge backlog the agency is dealing with, that is taking months and months to address these decisions, I'm having my folks get that application in, even if we think we're going to be successful. Because your debt goes away from the date that it's received by the agency, right? Not that, we wait. And because many of my folks are unemployed right now and not making money, if you're denied, you have to wait 6 months again to refile another chance at this waiver. And it's possible that in 6 months, our economy might look a little different. So I want to get that in for folks who are ineligible now, while they might be able to maximize their potential coverage. Here's some just general glossary terms. You might even see these words right there on your documents. Again, the primary point of all this is because I want you to be able to protest any decisions against you and use certain language, or just have a general understanding of what the agency is looking for prior to us having a hearing. This does not mean that unless you absolutely have to, that you should go to a hearing on your own. And so I'm gonna stop sharing this now. Okay, so that might be all I have for now as far as the presentation goes, unless Graham and I can just chat, or if you have any questions, Graham, about things that might be specific to restaurant workers or anything else that you've been seeing in all of your organizing and noticing things on social media, or what people have communicated with you.
Yeah, thanks so much for that, Tony. That was really helpful and informative. Yeah, I think the main thing that I wanted to address is that, yeah, all over, the different social media forums, in Detroit Restaurant Worker Forum, Service Industry Workers of Ann Arbor, all these different groups that I've been seeing, like you said, workers in all across Michigan I've seen have been, really expressing, they're really upset and scared because, yeah, they're getting these determinations that say, I owe $1,500, I owe $15,000, I owe $17,000, and not really knowing what to do. And, some people are saying, well, just let it go, the problem will fix itself. But I don't think anybody's really heard any sort of, gotten a firm answer. So I just kind of wanted to, with that, sort of recap some of the steps that people should be doing because I don't want people to be, sitting by and waiting for something if they need to be taking some action. So, so the first step is one that we want people to continue to file, right? Keep submitting your biweekly correspondences. The second thing is to continue to check the correspondences. Keep opening that tab. Go back through all of the back ones and check for any determination issues. When any of those determination issues pop up, protest it.
Absolutely. If it's against folks. Yep.
So if they determine against you, then protest. If they deny you, protest it again.
Absolutely.
When that happens, schedule an interview with an administrative law judge. And at that point, they should contact Sugar Law or the other advocacy groups that you mentioned.
Absolutely. In fact, the advice, if anybody has seen comments that say, let it go, it will fix itself, that's literally the only bad advice that can be given here. Proactive, it's just very important to be proactive, because the agency has this problem where even if you were eligible and you shouldn't have been flagged anyway, if you miss that deadline, the agency has taken the stance, even during Governor Whitmer's tenure, we still are against the worker because of the good cause issue, even though they were eligible for the other things. Mm-hmm. Even worse, Governor Whitmer recognized at some point that the backlog of getting through to the agency was nearly impossible. Chat versus phone. If you had any questions on how to protest, nobody was there to help you. So she even suggested to the judges, good cause should be found. It should be agreed upon during the pandemic based on how hard it is to get through to somebody, that we don't deal with the 30-day good cause issue. That lasted for a little while. Now judges have told me, unfortunately, they have to deal with that issue as a matter of law. That's very frustrating, because I've seen so many people just think, well, I don't know what to do. Maybe I'll get something else, and miss that 30-day deadline. And your second protest of your redetermination automatically schedules you the hearing with the judge. You don't have to do anything else other than file that same protest. And when you get that notice of hearing, you're supposed to get it at least 2 weeks before your hearing date. Sometimes it's hit or miss, but either way, that gives me some time to get it in my schedule. If you have any trouble getting through to me, if you read the fine print on your notice of hearing, there's an advocacy program that the state of Michigan provides, a 1-800 number. These are folks like myself who have done these for a while, / like me, took a test however long ago for 2 days on the ins and outs of unemployment. But I do suggest still trying to reach out to Sugar Law and the clinic at U of M, because although those advocacy folks are good, they are still under the gun. They do a lot of these. The reimbursement they receive from the state is very small. We use our nonprofit status, our law students, to dedicate more time and money to these hearings that don't really make sense as an easy fit in the regular market or in the regular private attorney bar. And that's why I think that they should try to get through to me if they have a hearing scheduled. Even myself in the clinic, we have law students sometimes help that can dedicate a lot of time and resources to helping do these hearings for folks. And your summary is very good. Really, I just am brokenhearted whenever folks get into Sugar Law and we're hearing a mask and we open their MyWAM and we see something they missed that said back in September you refused an offer of suitable work and you didn't see it. And now sometimes it doesn't let you click on MyWAM to protest after enough time has passed, so you'll have to fax that in. But generally, if you can protest it, just click it. A lot of my folks, I think because it's so user friendly, just missed that. And because just now in 2021, am I getting the backlog of hearings from March on, where now we're filling up every day? My whole advice for folks from the pandemic beginning through the end of the year was exactly what I just told you. As an attorney, I can't get into your MyWAM account. It could potentially cause all these additional problems if they see multiple sign-ins, right? You just got to be proactive, and if you know enough about it, train your fellow coworkers. Use those types of things to say, what are we all doing together? I'm always available for Know Your Rights presentations through the Restaurant Worker Forum, through any group that you all know, to train folks to deal with some of these, we'll call them internal protests that happen before I'd want to make sure they have a lawyer. None of this stuff they need to pay any money or do anything for once you know the ins and outs of it. And they can kind of empower themselves by spreading this to their other coworkers as well.
Yeah, that brings up just a follow-up question I had on that too, because I know a lot of times when I have sent folks over to Sugar Law or referred them to you specifically, one of the main concerns comes up is, well, I don't have money for an attorney right now. And I know Sugar Law does operate on a nonprofit status, but what sort of fees or whatever does Sugar Law collect in these sorts of instances, if any?
For any folks who are just calling me for any of these preliminary stages, it's completely free. To represent you at your hearing after the preliminary stages, it's completely free. If we're somehow either successful in your hearing and you then get eligible for benefits, we ask for a donation based on either the back pay that we may recover for you, or for, let's say, you're now eligible for multiple weeks moving forward. But it's a donation because we're a nonprofit. And it's my understanding that the clinic at U of M operates the same way. Advocacy program, I also believe it's free to workers. They get a small stipend or reimbursement, almost like a public defender from the state of Michigan. So there's a lot of snakes out there that are going to rip you off and act like it's a lot of money to represent you at a hearing. And desperate folks turn to those attorneys, unfortunately. We will give you the best representation without you having to worry about that.
Great. Thanks for clearing that up. Because, yeah, I would hate for that to be any sort of barrier for anybody who wanted to, to fight for the things that they should be entitled to. So, absolutely. Great. Well, I think that's all we had for this session. Can you send me a PDF of the Making Your Best Case, and I can make that available to folks who contact us?
Yep, I'm going to send that and the hardship waiver or affidavit of financial condition. Remember, you do both. You file your protest and the hardship waiver application. You don't say, oh, I'm just going to hope I don't pay it back because of my income, but not protest it. It's always both, right? And I'm also going to, I'll give it now, but you can also circulate it if needed. It's just www.sugarlaw, sugarlaw.org, O-R-G. The number is 313-993-4505. You'll either get myself or Shannon Stuckey. Let us know that you saw us through the Detroit Restaurant Worker Forum. My email is T like Tony, Paris like the city, so Paris, T Paris, at sugarlaw, sugarlaw.org. And especially if you get your notice of hearing, get at me more than once if needed. Our schedule fills up here. It's been a little hectic, so just be patient. And again, if you can't get a hold of me or we can't assist you for whatever reason, feel free to try the clinic, the Workers' Rights Clinic out of U of M Law School. And Rachel Cole should be your contact there. But I appreciate you all for not only listening to all of this, but any of you who are engaged in the Restaurant Worker Forum to kind of improve the rights of restaurant workers. More importantly, I really appreciate any of you who spread this information around and realize that you're able to do all of this and help your fellow workers on your own. And hopefully, gradually, we let the Unemployment Insurance Agency know that we are going to fight our eligibility and prove that this is something we have a right to.
Great. Thanks again so much, Tony. This was really awesome, and I think this is going to help a lot of people. And I'll put up the contact information again for the Sugar Law and Restaurant Worker News. And so if folks have any questions or need to follow up, feel free to contact us. Thanks so much.
Awesome. Thanks, Graham. Bye, everybody.